Okay, whoever's on the phone with the last four digits, 4032. I need you to unmute yourself, please. Can you tell me your name, please?
Phil Fierro.
Mr. Fierro. Okay. All right. We're on the record in Fierro versus Fierro. This is case number 0913148. The record should reflect that Mr. Fierro is on the phone here for this hearing today. We have Mr. Brzezinski present from friend of the court. This is set for a show cause hearing regarding payment of support. Mr. Brzezinski, can you tell me where things are at with this case today?
Yes, Your Honor. This hearing was adjourned from September 20th after the defendant appeared before referee legal. The referee recommended that the defendant be found in contempt of court as he's had available resources to pay all or some portion of the amount due, and he was ordered to pay $4,500 by today's court date or appear before Your Honor, and that payment has not been made.
Okay, what are you asking the court to do today on behalf of friend of the court?
The friend of the court would be seeking for the defendant to be found in contempt of court pursuant to the referee's recommendation, as the $4,500 payment was not made.
Okay, and would this be a first finding or a subsequent finding?
This would be a second finding of contempt.
Okay. All right, Mr. Fierro, were you able to hear all of that?
Yes, Your Honor.
Okay, so I need to go through a few things with you with regard to your rights. First of all, as indicated by Mr. Brzezinski, you are being charged with contempt for failure to pay child support. Because this would be a second or subsequent finding, the maximum penalty you could face if you're found guilty would be up to 90 days in jail. Do you understand that?
Yes, Your Honor.
Also, because there is a potential jail time penalty involved, you do have the right to have an attorney. If you can't afford an attorney, one would be appointed for you at public expense, or you can proceed on your own without a lawyer. Do you understand your rights with regard to representation?
Yes, Your Honor.
How did you want to proceed in that regard?
Currently, I have almost zero money. I was hoping to have this money on Thursday, and that fell through, and hopefully I would have it this week. So I don't know if that's going to matter for anything. I was negative $2,900 in my bank account for the past 8 weeks, which that bank account got shut down. I just opened a brand new one with Chase on Wednesday to try to get some money in there, which was like $140 to start it out. So I mean, I don't have a whole lot as of today.
Okay, well, I can tell you what your options are for today. You can request a court-appointed lawyer, and the court would refer that out and then set this for a hearing at a separate date. Or you can waive your right to have a lawyer and you can plead guilty to the contempt today. Do you understand those two choices?
Okay, yes. Then I would like to get public representation.
Okay. So the court will enter a not guilty plea on your behalf today with regard to the contempt charge. The court will refer this to Mr. Gilo's office. And so the lawyer's name is Gary Gilo, and his office will be contacting you, Mr. Fierro. When they contact you, it's important that you follow up with that. They're going to look at your financial situation and see whether or not you qualify for a court-appointed attorney. Either way, we'll set this for a hearing at the next available date, and you'll be notified of the date and time of that hearing. If you're able to make any payments, or you want to talk further with a friend of the court, then I would encourage you to stay in contact with Mr. Brzezinski as we get closer to that hearing date. Do you have any questions about that?
Not about that. I do have a question about being held in contempt of court for 2 times. This would be the only first one that I can recollect since 2009 when the case started.
Okay, well, that's something that we can look at for purposes of that next hearing. Obviously, if you either have or you haven't, so that's something that we can check with our records.
Okay.
All right, Mr. Brzezinski, as to this file, anything further that we need to address today?
No, Your Honor, and the previous finding of contempt was September 8th of 2010.
Okay, so Mr. Fierro, I don't know if you heard that, but back in September of 2010, so it's been quite a while, but our records do reflect that you had a contempt finding back then.
Yeah, I don't remember since it's been so long. Okay.
Okay, thank you. You're free to disconnect at this time. Again, make sure that you stay in touch with Mr. Brzezinski at friend of the court.
Okay, when would I find out about the next hearing so I make sure I'm a part of that? Or would I find that from Gary Fellows?
We'll send you notice, but you're free to contact Mr. Gilo's office at any time as well.
Okay, very good.
Okay, thank you. You're free to disconnect at this time.
All right, thank you, Your Honor.
All right, I think we have Mr. Burke perhaps trying to connect here. And you just need to unmute.
Okay, all right. Sorry, I'm new to this.
That's all right. Can you tell me your name, please?
Eric Burke, Eric with a C, B-U-R-K-E.
All right, thank you. We're on the record in Burke versus Burke. This is case number 0913013. The record should reflect Mr. Burke is present today by video. Mr. Brzezinski is here on behalf of friend of the court. Mr. Brzezinski, can you tell me where we're at with this file today?
Yes, Your Honor, this hearing was adjourned from September 20th after the defendant appeared before referee legal. The referee recommended that the defendant be found in contempt of court. As since April of 2022, he has had the ability in periods where he was employed and still did not pay his obligation, and he receives monthly income from the VA. He was ordered to pay $2,500 by November 6th or appear before Your Honor this morning, and no payment has been received to date.
All right, and would this be a first or second or subsequent finding of contempt, Mr. Brzezinski?
This would be a first finding of contempt.
Okay. All right, so Mr. Burke, we need to go through a few things with you with regard to your rights in this case.
May I? Okay, I'm sorry. I just everything's wrong here.
All right, well, let me go through your rights and then we'll see where we're gonna go for purposes of today's hearing. First of all, you need to understand that because you're being alleged to be in contempt of a court order for failing to pay child support, that the maximum penalty you could face would be up to 45 days in jail. Do you understand that?
I'd rather wait for a lawyer, please.
Okay, I'm not asking whether you agree with that. I'm just asking whether you understand that that's the penalty you could face if you're found guilty of contempt for failing to pay child support.
I'm gonna wait for a lawyer, if you don't mind, Your Honor. I'm not trying to be disrespectful at all.
Are you saying you don't understand what the maximum penalty is?
No, I need someone to explain it to me.
What don't you understand about the possibility that you could face up to 45 days in jail if you're found guilty? What don't you understand about that?
I'll wait for a lawyer, please.
All right, you're not subjecting yourself to any criminal penalties by saying whether or not you understand the maximum possible penalty. So you don't have the right to remain silent on that question. Do you understand that or don't you?
I understand, but I'd rather just have some representation for me before I continue.
I get that, I understand that, okay? And I'm not gonna make you make any statements on the record here today that could expose you to criminal liability. But it's my job to make sure that you understand what your rights are. You get that?
Yes.
Trying to make sure that you understand what your rights are and what you could face. I'm not trying to get you to say something that's gonna hurt you. Do you understand that you have the right to have a lawyer, and that if you couldn't afford one, one would be appointed for you at public expense? You also
Yes.
have the right, you also have the right to represent yourself. Do you understand those rights?
Yes.
Are you gonna hire your own lawyer? Did you want to see if you qualify for a court-appointed lawyer?
Court appointed, because I don't live in Michigan, so I need that'd be too expensive. I can't afford it.
Okay, so I'm gonna refer you to an attorney named Gary Gilo. He's our court-appointed program administrator. He's gonna review your case to determine whether or not you qualify for a court-appointed lawyer. If you do qualify, then he'll appoint a lawyer for you and you'll be informed of who that is. When his office contacts you to make that determination, that you need to cooperate with them, and if you want to have a court-appointed lawyer, and provide the information that they need to make that determination. If you don't supply that information to them, then you just won't qualify. Do you understand that?
Yeah, I just don't understand why. I've been honest with my son's mom and honest with the friends of the court, and I started a new job that I really like, and I make a decent amount of money, and I was just going to start paying it back. I don't get why I'm in trouble.
It sounds like because you haven't made any payments since April of 2022.
I was unemployed. I'm sorry.
All right.
I didn't mean to sound brash.
Something's happened.
I'm sorry.
Something's gone on since April of 22, and we'll get it straightened out. And if you have a reasonable reason for not paying, then you won't be in trouble. If you don't, then you might.
Sorry if I sound brash. I just, it's very, very frustrating.
So the court will set this for a hearing. You'll be notified of the date and time of that hearing by the court. And you'll be contacted again by Mr. Gilo's office for a determination. It's important that you follow up with that contact, okay?
Yeah, that's fine. I have no choice, right?
You have lots of choices, and Mr. Gilo, will be able to advise you on that as your lawyer.
Yeah, he looks like he's 12 years old.
So first of all, that's not Mr. Gilo, that's Mr. Brzezinski. And
I know. I understand. I understand.
Certainly by personally insulting people involved in the process, you're not going to help yourself.
I'm just, Your Honor, I apologize. I'm frustrated. I've been trying to fix this for months and months.
Okay, well, we'll see where we go from here. But again, insulting people involved in the case is probably not going to help your cause. So you can find a way to deal with your frustrations. We'll see if we can get this figured out.
All right, Your Honor. Thank you.
That's all for this hearing today. Again, look for the notice of the date and time of the next hearing in the mail, and you're free to disconnect.
Hey, I'm sorry I said that about you. I apologize.
Okay, the last case we had is Wilkinson versus Wilkinson, case number 2319416. I don't see any of those parties in the Zoom waiting room. As to that file, Mr. Brzezinski, how did you want to proceed?
I believe it was a status conference, and the parties recently appeared before referee legal in October and came to a parenting time and custody agreement. And so the friend of the court was just waiting to do a child support recommendation. We need the defendant's info before we can send out the judgment of divorce to the plaintiff.
Okay, all right, thank you. Any other matters we need to address today?
No, Your Honor, thank you.
Okay, that's all for today. Thank you for your participation. Okay, looks like we have counsel connected. We'll go on the record in let's see, Haskell versus Haskell. This is case number 2218880. If I could just have both counsel put your appearances on, please.
Sure. Zach Backlund on behalf of Aubrey Haskell, Your Honor.
Good morning, Judge Elliott Blumberg on behalf of David Haskell, who's appearing via Zoom from my office.
Okay, Mr. Backlund, I don't see your client in the Zoom waiting room. Can we go forward without her present?
Yeah, we can. And I told her about the hearing, and a part of, what we're explaining today is a potential adjournment. And I think that might have confused her in thinking that maybe today was adjourned as well. So.
Okay, this was set as kind of a final status conference. We do have a bench trial date coming up. So Mr. Backlund, how did we want to go forward then?
Certainly, Your Honor. I've spoken with Mr. Blumberg about potentially moving our trial date back approximately a month. And we have a potential date that Mr. Blumberg received from Ms. O'Rourke and was going to prepare a stip to adjourn that, which I would sign. Mr. Blumberg and I have discussed the discovery, and I think with some additional disclosures to one another, we might be able to narrow our focus a bit and provide, better information for the court as well to conduct that trial. So we were hoping to do that, and to that end, Mr. Blumberg got the additional trial date for us in December to conduct that.
Okay, Mr. Blumberg.
Judge, that's an accurate statement. There's been a bunch of new financial information that Mr. Backlund's received that I have not. And plus, both these parties were unrepresented at the beginning of the case, and I noticed that neither party has filed a verified domestic relations financial form. I think that's something that we both need to have done. And again, Ms. O'Rourke was able to get us a day for you to preside over a bench trial in December. So I think it would be best for everybody, including you, if we were able to get that adjourned.
Okay. All right. So as we already have a new trial date, the court will adjourn the current date and we'll proceed with the new date in December. Mr. Backlund, anything else we need to address from your side today?
The only thing I would add is procedural, and I think Mr. Blumberg, Ms. O'Rourke, and I have all exchanged emails. There was a potential hearing on the child support coming up, and we were going to merge that into our trial date as well, rather than have a hearing with the front of the court and our trial date.
Okay. And I believe I did get that communicated, and so I think we'll address all issues on the same day. Mr. Blumberg, you're okay with that as well?
Sure, that's fine.
Okay. Okay, Mr. Blumberg, anything further from your side?
No, Judge, thank you.
Okay, thank you. That's all for this hearing. Mr. Blumberg, if I believe you're up for the other 9:15. Did you need me to put you on hold for a minute?
Well, I think we just have to grab, she's in the waiting room, so if you don't mind, just a second. She's being filmed.
Thank you. I'll bring Mr. Dundon in, and Mr. Backlund, you're free to disconnect. Thank you.
Thanks, Elliot. Okay, David.
Hi, good morning.
Your Honor, Ms. Tomasky has just arrived from our waiting room, so we're ready to go.
Okay, thank you. Okay, we're on the record now in Tomasky versus Tomasky, case number 2319198. If I could have both counsel put your appearances on, please.
Good morning again, Judge Elliott Blumberg on behalf of Tomasky, who is appearing via Zoom from my office.
Good morning, Your Honor. Mark Dundon appearing on behalf of Daniel Tomoski, who is appearing via Zoom.
Okay, thank you. This is set for a status conference. It looks like the last time we met was back in September. Mr. Blumberg, where are we at and how do you want to go forward?
Judge, I think, and perhaps Mr. Dundon can correct me, I think we've come to an agreement on the issues of custody and parenting time. Support is still an issue because it's related to Mr. Tomoski's involvement in a business in which he was an owner. So the property issues are not yet resolved, but I think we're getting much closer on resolving the custody and parenting time.
Okay, Mr. Dundon.
I agree, Your Honor.
And Mr. Blumberg, going forward from today, do you want the court to set a deadline for mediation? Or how do you want to schedule this?
Yeah, I have no problem with that. We're still, and again, this is not a fault attributed to Mr. Dundon. It's Mr. Tomoski's company has their own attorneys that have been very hesitant and reluctant to provide documents that we've requested. So that's kind of the holdup. So we agree we need to go to mediation, but I think for mediation to be meaningful, we need to have a better sense of Mr. Tomoski's interest in this company.
That's correct, Your Honor. If I may briefly, we also had asked for there's another account that Ms. Tomoski has, I believe, that her real estate commissions go into, and we've requested that. I believe Mr. Blumberg said we're going to get it shortly, so we need that as well on our end in order to make mediation effective. Other than that, I agree with everything Mr. Blumberg said. If we get that information, I think it would make mediation more productive.
So if we set a mediation deadline at 90 days, Mr. Blumberg, do you think that'd be enough time?
Absolutely, yes.
That
Okay,
works on our end, Your Honor.
Okay, so the parties, of course, are free to schedule that at any time, but we'll say no later than 90 days, and then the court will set it for a status conference after that period expires. If the parties have been able to reach an agreement, then we can use that date to enter proofs. If not, then we can set further dates going forward. Mr. Blumberg, anything else that I can address for your side today?
No, Judge, thank you very much.
Mr. Dundon?
No, thank you, Your Honor.
Okay, all right, thank you. That's all for today, and all parties on this case are free to disconnect at this time.
Thank you, Your Honor.
All right, Ms. Bidwell, are you connected?
Yes.
Okay, and let's see, Mr. Smith, I'm gonna need you to unmute yourself, please. Okay. All right, so we're on the record now in Smith versus Bidwell. This is case number 1817430. The record should reflect that both parties are connected here today remotely. And we're set for a hearing today. Mr. Smith, you filed a motion to revoke acknowledgement of parentage of 2 children in this case. Is that correct? Sorry, I couldn't hear you. Can you repeat that?
Yes.
Okay. All right. So the next step in that process, Mr. Smith, is the court is going to sign an order for genetic testing. Once that order is signed, then you'll need to participate in that. Do you understand that?
I do.
Okay. And Ms. Bidwell, you'll also need to participate in that pursuant to the order in terms of making the children available for any DNA samples to be taken, okay?
Okay.
So the court's going to sign that order today. Mr. Smith, you're going to need to come to the clerk's office and get a copy of that signed order so that you can get the testing that's required.
Okay.
Court's going to require that that be done within the next 60 days, and the order will reflect that as well. And then we'll set this for another hearing at that point. Once we have the results of those tests, then we'll see where we need to go from there.
Okay.
Mr. Smith, did you have any questions at all?
No, Your Honor.
Ms. Bidwell, did you have any questions?
No, nothing on this.
Okay. All right. Thank you. That's all for this hearing today, and both parties are free to disconnect at this time.
All right. Thank you.
Thank you, Your Honor.
All right, Ms. Faupel, good morning. Are you hearing on the Lappin matter?
Yep.
Okay, I don't have that set until, let's see, 10:45. So I'm just gonna keep you in the waiting room unless you want to disconnect and reconnect then.
I think I'm on the wrong time zone here. So yeah, I think I'll sign out and come back in an hour. So
Okay, sounds good. Thank you.
thank you. Yeah, bye-bye.
Good morning, Your Honor.
Okay, good morning. It looks like we have all counsel. Please check in here. Let's see.
I am here, Your Honor, Jody Doak, on behalf of Michaela Daniel Bergman.
Okay, thank you. Ms. Olowski, are you there?
I am here, Judge, on behalf of Tyler Hassel. Mr. Hassel
Okay.
has the flu right now, so I don't believe he's going to be appearing this morning.
All right, thank you. We're on the record then in Hassel versus Bergman, case number 1716873. The record should reflect that both counsel are present, and Ms. Bergman is also present by video. Ms. Doak, this is your objection, and I believe, correct me if I'm wrong, but your objection is just relating to the date, the effective date of the current support order. Is that correct? You're muted.
I apologize, Your Honor. That is correct. Can you hear me now?
Yes. So can you just, I know that it's in writing, but can you just state your position for the record here today?
I can, Your Honor. So we had a hearing in front of the referee with regards to support, and this case had proceeded upon a long procedural history where my client had filed for custody, and then there was an adjournment while some parenting time was implemented. Then we came back, we renewed our motion for custody. It actually started with an ex parte order that was filed initially in the case, and then it proceeded to hearings, and then we came upon June 29th, 2022, and that's when a final order was entered that was not appealed. I attached all of these exhibits to my motion. So on 1/27/2022, we have a referee findings and recommendation after a hearing on parenting time. No party objected to that recommendation, and it stated that we had preserved testimony of two witnesses when we were calling our motion for custody, support, and parenting time. And then the hearing was continued to March 30th for a 2-hour evidentiary hearing. And that specifically says that defendant's motion for custody, parenting time, and support were to be heard at an adjourned hearing in March. That date was January 27th, 2022. Then there was multiple adjournments, and then a recommended order was entered on June 29th, 2022. That was objected to by the plaintiff and affirmed by this court in a written decision. So we believe the effective date of child support should be July 19th, 2021. That was when child support was first requested. The father in this case knew that child support was requested. The mom has been caring for these children by herself since before July 19th of 2021. And he chose not to pay any support, not to take any action during this time period. If the court does not choose the July 19th, 2021 date, there is no doubt on the record that as of January 31st, 2022, there was no objection to the referee's recommendation that stated that a hearing for custody support and child support was going to be adjourned. And at that point, of course, everybody knew that child support was requested as of that date. So we're requesting that the effective date of the order would be July 19th, 2021, or in the alternative, if the court does not find that date to be appropriate, January 31st, 2022.
All right, thank you. Ms. Olowski?
Thank you, Your Honor. So obviously, most of these hearings that Ms. Doak is talking about occurred prior to my involvement in the case. I've come in kind of on the backside of this, but I believe we take the same position that the referee took at the hearing in June, where the effective date for the recommendation, he ordered it would remain June 29th, 2022. And I believe the reasons that were articulated on the record at that time were due to the fact that there was no objections that were filed, and the only objection that was filed by the plaintiff to that order, and there was no further objections that had been filed regarding support leading up to that point. So without being involved in all those prior hearings, that would be our position. So we believe that the June date would be the correct date.
All right, Ms. Doak, any response to that?
Yeah, the hearing in June did not, it addressed custody, parenting time, and referred for a recommendation of child support, but it did not determine a retroactive date for child support. So I don't think that her argument makes sense in this light. And I think the law provides that it goes back to the date that we first requested child support. So I think that supports our position.
All right, thank you. I did have a chance to review the file. I was already familiar kind of with the procedural history of this, given the court's involvement in the objection from the plaintiff. I had a chance to review documentary history as well as the referee's rationale and reasons for finding that the June 22 date was the effective date. And I've also had a chance, of course, to review the statutes that apply here. And it's my view, I agree with the referee in this case. And it's my view that until we had a final order regarding custody and parenting time, that is what would trigger the date for support to begin, because that's what everything would be based on. So the court finds that the referee's conclusion as to the date that support begins is the correct one based on the history of the case as well as statute. And so the court will deny the objection. And Ms. Doak, the court would just request that you prepare an order that reflects that ruling in the court today, and either submit that with an objection as to, or with a stipulation as to form, or under the 7-day rule.
Sure.
Ms. Doak, anything further that I can address for your side on the record today?
Nothing further.
Thank you. Ms. Olowski, anything further from your side?
No, sir. Thank you.
All right, thank you. All parties on this file are free to disconnect at this time.
Thank you, Your Honor.
Hi, Judge Mertz. I'm going to have the case manager sign on for the rest of the morning docket, okay?
Okay, sounds good. Thank you.
Yep, thank you. Have a good one.
Okay, Mr. Rolla, are you able to hear me okay? You did.
Should be unmuted now. Thank you.
Okay, and let's see. Ma'am, are you Amber Hofflick?
Yeah.
We're on the record now in Hofflick versus Bushbell, case number 2319271 DS. The record should reflect that the plaintiff is present here by Zoom video, as is Mr. Rolla on behalf of the people. This is the date and time set for entry of the default judgment of support. I am in receipt of that proposed judgment. Mr. Rolla, anything for the record on behalf of the people today?
Well, Judge, in light of the defendant's failure to respond, the people would ask that it be entered in the child's best interest.
Thank you. The record should reflect that the defendant was properly served with the summons and complaint in this case, that he did fail to respond in any way, that a default was granted back in September. He was provided notice of the date and time of today's hearing, which was 10 o'clock. It's now past that time and he is not present. Ms. Hofflick, you understand that under this order, it would provide that you would have sole physical custody of Adriana, your daughter, as well as joint legal custody. Do you understand that?
Yes.
And then this order would also provide for payment of child support by Mr. Bushbell to you on behalf of Adriana. You understand that as well?
Yes.
As a mother of Adriana, is it your opinion that entering these orders today would be in her best interest?
Yes.
Okay. Based on Ms. Hofflick's statements here on the record this morning, as well as the information contained within the file, the court finds it would be appropriate to enter those orders at that time. And the court signed both of those. Ms. Hofflick, did you have any questions at all?
No.
Mr. Roll, anything further on this file today?
Just let the plaintiff know our office, after we receive a copy of the order, we'll make sure she's provided with one. Thank you, Judge.
Thank you. Ms. Hofflick, that's all for today, and you're free to disconnect at this time.
Thank you.
And then I have Ms. House connecting for the other 10 o'clock right now.
And Your Honor, for the record, I would indicate to the court, it's Mr. House is in the Otsego County Jail.
Okay, thank you. All right, Ms. House, are you there? Can you hear me?
Yes, I am.
All right, are you Melissa House?
Yes, I am.
Okay, we're on the record in House versus House, case number 2319367. The record should reflect that Ms. House is present here today, as is Mr. Rolla on behalf of the people. This is the date and time for entry of a default judgment of support. I am in receipt of that proposed judgment. Mr. Rolla, anything that you wanted to state for the record today?
Judge, in light of the defendant's failure to properly respond, with, of course, the proofs of service that are contained in the file as to his being served with a complaint, and as the people believe would be in the minor child's best interest, we'd ask the court to, of course, confirm that information with the plaintiff who's present, and then have the order entered. Thank you.
Thank you. So, Ms. House, you understand that the order that the court would enter today involves your child, Rebel Anthony Cash House?
Yes.
Okay, and you're the biological mother of that child?
Yes, I am.
You understand that under this order that you would share custody of your child with Mr. House?
Yes, I do. Is he, I'm sorry to interrupt, but is he part of this hearing right now?
He's been defaulted and Mr. House was served with that default. He's made no attempts to contact the court and request to be present for the hearing today, even though he is in the Otsego County.
When I had spoken to Miss Kent, we assured him that he could be part of this. So if he had any questions or concerns, that he could address them.
Okay, yep. Well, he hasn't made any attempts to contact the court or request to be present for the hearing today. So it's my intent to go forward.
Okay, well, he probably didn't, because when I spoke to him about the hearing, I relayed the conversation with Miss Kent that he would be part of it, that if he had any questions, he would be included. And he did get the notice of when it would be, but it was our understanding that he would be included in it. So he didn't realize he had needed to do anything different, and neither did I, to be honest.
All right, are you asking me to adjourn this until he's present?
I would very much like him to be present, Your Honor.
Okay.
It's, we get along very well. I'd like to keep it that way. I did assure him, because of our conversation with Miss Kent and with him, that he would be part of it. So when he got his paperwork, if he had any questions or concerns, that he would be able to address them today. And if he's not part of it, I don't feel comfortable going on with it. I don't want him to feel like anything's being done without his knowledge.
Okay, Mr. Rolla, do you have any objection to the court renoticing this hearing? Mr. Rolla, are you there? I think we got some connection issues, Ms. House. Just hold on one second.
Not a problem.
Okay, are you back with us, Mr. Rolla?
Yes, Judge, I apologize. I don't know what happened. It just decided to kick me out while you were speaking. So I was unable to hear.
I had
the
a hard time
response-
getting
last
into it this
response from
morning.
Ms. House.
Okay, do you have any objection to adjourning this hearing and issuing a writ for Mr. House to appear from the jail?
We can, Judge. I don't have any problem with that. Obviously, I did advise the court at the beginning of this hearing that we knew he was there, but he had made no request to appear before the hearing as far as I knew. But our office can have a writ done, provided he, of course, will still be in the Otsego County Jail at the time of the next hearing.
His
Okay.
release date as it stands right now is December 22nd.
So as long as we have it before that time, Judge, the people have no objection. Thank you, Ms. House.
Okay, we will set it before that time. Mr. House was defaulted in this case, so I, there's no legal reason, and there wouldn't be anything from a procedural standpoint improper about the court going forward. But Ms. House, I understand your concerns, and in the interest of that, and with no objection from Mr. Rolla, then I don't have a problem adjourning it. So we'll set it for another date. You'll be notified of that date, Ms. House, and the prosecutor is going to prepare a writ for Mr. House to appear from the jail hearing. All right.
I apologize for having to adjourn it. My understanding is that he was already, that the jail was notified of it. I could have swore that Ms. Kent told me that she was making arrangements for him to be part of it.
I'm sure that I'm sure that the proper notices were given, but there has to be, when somebody's in jail, there has to be a specific request that's signed and ordered by the court to make them available. So we'll do that for the next hearing, and then we'll go forward then.
Okay, and I will do my best to follow up and make sure that we get it all set so that we don't have to have this again. I apologize.
Okay. No need for an apology. Thank you. You're free to disconnect at this time.
Okay, thank you so much, Judge.
And Mr. Rowley, you're free to disconnect as well.
Very good, Judge. Thank you.
Our next hearing set for 10:30, so the court will take a short recess until that time. Okay, whoever's on the phone with the last four digits, 2622, can you tell me your name, please?
Hi, Jason Corby.
Mr. Corby, okay. If you could just hold for 1 second, all right?
Okay, no problem.
All right, ma'am on the iPhone, can you tell me your name, please?
Lindsay Sevener.
Okay. All right, we're on the record in Corby versus Sevener. This is case number 1415238. The record should reflect both parties are present today. Ms. Sevener, I have listed here that Mr. Blumberg is your attorney. Is that correct or no?
No, I do not have an attorney.
Okay. All right, so we're set today for a scheduling conference. Ms. Sevener, you asked the court to modify the parenting time in this case with regard to your child. Is that correct?
Yes.
All right. And Mr. Corby, have you seen Ms. Sevener's request with regard to parenting time?
Yes, I have.
Okay, are you objecting to that?
I offered Miss Sevener more parenting time. I just don't like overnights during the week with school and everything else like that.
Okay.
That's my biggest problem.
All right, Ms. Sevener, do you have any objection to going in front of a mediator to see if you guys can reach an agreement with any kind of change in parenting time?
No, I don't.
Mr. Corby, do you have any objection to that?
No, I mean, that's not a problem.
Okay. All right, so I'm going to refer this to mediation. Somebody from the front of the court or the mediation service will be in touch with each of you to set up a date and time that works for both of you. And if you can reach an agreement, that's great. If you're not able to reach an agreement on that, then Ms. Sevener, the next step would be the court would set it for a hearing, and then we would take some testimony, and then the court would make a decision, okay?
Okay.
Do you have any questions about that process?
No.
Mr. Corby, do you have any questions about how we're going to go forward?
Nope. We've gone through this before with mediation.
Sure. Okay. All right. Thank you. That's all for today, and you're both free to disconnect at this time.
Thank you.
Okay. Thank you.
Okay, looks like we have everybody connected, so we'll go on the record in Lappin versus Johnston, case number 07-12201. If I could have both counsel put your appearances on, please.
Marion Popple representing Cody Johnston.
Morning again, Your Honor. Elliot Blumberg on behalf of Kristen Lappin.
Okay, we're on the record here today. Ms. Popel, your client filed an objection to the latest child support review. I had a chance to review his written submission, although it looked like that came from him, not necessarily from you. And it sounds like he's asking for some kind of retroactive modification to support. So I don't know if you could maybe streamline that or boil that down to the court for what you're asking the court to do here.
All right, Your Honor, he did file the objections in pro per and then asked me to represent him today. The court's aware of the background here where the mother was in prison for some time and custody changed here and there. But what happened was that he initially had asked for a custody change in September of 2021. And the case was on hold a bit because there was this DHHS case that was pending. That was closed in May of 2022. And in April of 22, the friend of the court started doing a child support review, and Cody turned in his paperwork the first week in April in 22, but Kristen didn't turn in her things until later on, and there were other delays that Cody outlined in his motion. But at this point, as you know, he's had primary possession of Cameron for a long time now, and he's just asking that this be retroactive to when he actually had primary possession. I know we recently had this custody hearing, and so I know it's a difficult case, Your Honor. They're both relatively low income, but it's really the retroactivity that he's concerned about. And as I say, initially this began in September of 21. The DHS case was closed in May of 22, and he's had primary possession since then, as you know.
So I guess my question is this, because there was a support modification order entered in September of 22, which is the last one prior to the most recent one that was entered this year. And there were no objections filed to that order in September of 22 by either side. Then, of course, we had the court's decision in this case. And so then the court issued its ruling. And then we had another review and modification here just recently in September of this year. So I don't understand what your request is in terms of what part of that are you asking to be retroactive? And if we have an order that was entered in September of 22 and that wasn't objected to, then how can we go backward from there and go all the way back to 2021 when we have an order that's been in place for a year? I guess, and what would be the statutory authority for that or otherwise?
Well, the statutory authority it goes to when someone files their motion to change custody or parenting time, and then the child support can relate back to them to that point. There's been changes in income here, changes in parenting time. The court will have to decide what's the appropriate date. But I think the problem here is that the burden of supporting Cameron has been on the father, and he's filed, immediately to have primary possession after the DHS case was closed. He's had the burden of supporting him. This is a little bit unusual because he initially filed to change the parenting time in September of 21, and then the whole case was on hold because of the DHS case. And then when that finally was closed, then you had jurisdiction again to decide the pending change of custody. And of course, the mother then filed her complaint last fall, and I represented him during your evidentiary hearing. But if we go back to his original petition for a change, that was in September of 21. And as I say, it was delayed by two things, really, because of the CPS investigation and the DHHS orders. And then it was also delayed because the mother hadn't really turned in her paperwork on time. So this all resulted in, delay after delay. And now we're in October of 23, and he is, really struggling here because she just really does not contribute to support in any meaningful manner.
All right, thank you. Mr. Blumberg?
Judge, I think you've identified the issue pretty clearly. In 2022, there was a support order that nobody objected to. That was the order of the court up until the time of the custody hearing. Based on your opinion, an order was entered in September of 23. That should be the effective date of the new child support recommendation. That should become the order. Nobody seems to be objecting to the amount of the recommendation, but rather the retroactive date. Seems to me when you wrote your opinion and that became the order of the court, that's the effective date of the new support recommendation.
Well, my only response to that.
All right, thank you. Ms. Falpel, anything that you wanted to say in response?
Well, just that, when I became involved in this case, both parties had these pending motions before you that had been filed last fall. So if, you enter a child support order that's effective now, a year later, this is really going to burden Mr. Johnson, who timely filed his motion, proceeded on it, went through the evidentiary hearing, and this is a mandatory issue when it comes to child support. They both have an obligation to provide support. It can be retroactive to the date of the petition, which was last fall. And he's had the burden of supporting Cameron. So we'd ask that it go backward to at least last fall when the competing petitions were filed.
All right, so I've had a chance to review the file again. Obviously, I'm familiar with the procedural history of this case based on the hearings that we've had. And considering the arguments of counsel here on the record today, as well as the statutory authority, which in my view would allow for retroactivity only during the pendency of filing of a petition for support, not necessarily the filing of motions for changing custody or parenting time. I mean, those are two completely different issues. So the court looks at what is the most recent support order that was entered prior to the one that's being challenged now. And that was an order entered last September. As I indicated, the file does not reflect that either side objected to that order. So in my view, child support was set as of September of 2022 without any objections. And so the court doesn't find that there's any statutory authority that would allow it to go backward from that order. I mean, that is the order at that time. So we'd only be looking forward from that. And so the court then issued its ruling, which did change the custody and parenting time orders. The friend of the court did a review and modification, which was provided here in September of this year, updating it based on those changes. The challenge here, or the objection here, as I think Mr. Blumberg correctly pointed out, isn't to the amount, it's just solely dealing with this retroactivity issue. And at this point, the court doesn't find that it would have any statutory authority to go retroactive to or backward from September of 2022. And in terms of the pendency since September of 2022, again, there wasn't any objection to that order at the time it was entered. And everybody was well aware of the issues related to parenting time and custody at that point. So the court doesn't find there would be any reason to go back to September of 2022 either. So in my view, we're starting with a child support order that's The most recent one was entered 2 months ago. That's the one that will remain in effect along with current custody and support orders. So, or custody and parenting time orders. So the court denies the objection on those grounds. And Ms. Papel, the court would request that you prepare an order reflecting the ruling of the court today and submit that either with the stipulation as to form or under the 7-day rule.
All right, thank you.
Thank you, Judge.
Thank you. That's all for this hearing today, and both parties are free to disconnect at this time. Mr. Johnson, if you have further questions, I would recommend that you contact Ms. Papel. She can help you with that.
Thank you.
Okay, looks like we have counsel connected. Ms. Kester, if you can unmute yourself. We'll go on the record in Hogg versus Hogg. This is case number 2319358. And if I could have both counsel put your appearances on, starting with plaintiff, please.
Good morning, Your Honor. Shelley Kester on behalf of Party A in this collaborative divorce matter. My client is Ashley Hogue.
Randy Velson, excuse me, representing Party B, James Hogue.
All right, thank you. We're on the record today for purposes of a scheduling conference in this matter. And I understand the parties are possibly have an agreement at this point and wish to enter proofs. Ms. Kester, can you tell me where things are at from your side?
Thank you, Your Honor. I believe the court received a stipulation to cancel pretrial conference and use the time for a pro confesso. In our stipulation, we cite the statute and the applicable court rule. The parties signed a participation agreement and have been engaging in a series of meetings with the aid of Craig DeWitt, a mental health professional. The parties have a draft property settlement agreement and are very close to resolving the issue of spousal support and how that interrelates to their retirement. They've been very cooperative, collaborative. And as our stipulation signed by both Mr. Bells and I indicates, we are highly optimistic we'll have a signed consent judgment and marital settlement agreement by the 20th of the month. Parties are very motivated to conclude this matter before the end of the year, been very respectful. And so we would ask the court to allow us to put on the statutory proofs to be preserved for that purpose.
I
Great,
agree
thank you,
with
Mr.
everything.
Nelson.
Thank you, Your Honor. I agree with everything that Shelley said. We had a hour-plus meeting this morning just before this session and made great progress. There's just always or often tricky issue of spousal support is really the only significant hurdle between us and the finish line.
Okay, Ms. Kester, then I'll swear your client in and we'll take proofs. Ms. Hoagie, can you raise your right hand, please? Thank you. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
I do.
Thank you. Ms. Kester, please proceed.
Thank you, Your Honor. Ashley, would you please state your full name for the record?
Ashley Janae Hogue.
And were you legally married to James Hogue by a person authorized for form marriages in the state of Michigan?
Yes.
And at the time that you filed these pleadings with the court, have you and James been a resident of the state of Michigan at least 180 days?
Yes.
And have you been a resident of the county at least 10 days before the paperwork was filed?
Yes.
Otsego County. Is it true that there's been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed?
Yes.
Is there any reasonable likelihood that your marriage can be preserved?
No.
Are you currently pregnant?
No.
You and James have 2 children, 2 beautiful boys. Is that right?
Yes.
Harrison and Hudson, ages 7 and 4.
Yes, ma'am.
And you and James have been married for approximately 10 years. Is that right?
Yes, that's correct.
And you and James have reached an agreement for joint legal and joint physical custody with equal parenting time between you and James over the care and custody and parenting time for your boys. Is that right?
Yes.
Do you think that agreement is in their best interests?
I do.
And is that agreement set forth in a separate parenting agreement that you and James are in the process of signing?
Yes, it is all set forth.
And that was reached with the assistance of access to Mr. Belden and I, but also with the input and support of Craig DeWitt, a mental health professional.
Yes, Craig helped us draft that.
And you and James have also fully disclosed to each other the assets and liabilities that each has jointly or individually in the course of your marriage to one another. Is that right?
Yes.
And while we don't have everything signed, we're very close. And do you agree with me that it's likely that you and James will have a full resolution with a signed settlement agreement in this manner?
Yes, 100%.
And has anybody threatened you or pressured you or forced you to come to the agreements that you're reaching, or as far as you know, will reach by the end of this month?
No, ma'am.
And you haven't threatened or coerced anyone to reach an agreement, have you?
No, I have not.
And you're intending what with regard to your last name and upon entry of the judgment in this case?
I'd like to go back to reside to my maiden name of Jenkins.
Okay. And you agree that there's been a breakdown of marriage relationship to the extent the objects of matrimony have been destroyed and there's no reasonable likelihood the marriage can be preserved?
Yes, ma'am.
I have no further questions of my client, Your Honor.
Thank you. Mr. Belson, did you wish to ask any questions of Ms. Hogue?
No, Your Honor, thank you.
Did you want to take any testimony from your client?
I don't think it's necessary.
Okay, all right, thank you. The court finds that the statutory grounds for divorce have been met by the testimony of Ms. Hogue. The court will grant the divorce. I'm just going to put in the pretrial order, counsel, that we've taken the proofs today and that the parties will submit that judgment within the next 30 days. Just let my office know in writing if you do need more time than that. And then once that's submitted, the court will sign it. Ms. Kester, anything else I can address for your side today?
No, we just like to express thanks to the court for accommodating the parties in their collaborative process, and like to thank Mr. Hogue or Mr. Velzen for his assistance in this collaborative process as well.
All right, you're welcome. Thank you. Mr. Velzen, anything further from your side?
Just appreciate the court's cooperation.
Okay, thank you. That's all for today, and all parties are free to disconnect at this time.
Thank you, Your Honor.
Thanks, Your Honor.
Okay, Mr. Cadet, are you able to hear me okay?
Yes, good morning, Judge. Can you hear me also?
I can, thank you, and good morning. We're on the record in Ingersoll versus Ingersoll, case number 2319438. The record should reflect that Mr. Cadet is present here today on behalf of Ms. Ingersoll, who is present by Zoom as well. Mr. Ingersoll is not present. This hearing was scheduled for 11 o'clock. It's now 11:08. We're on the record today for purposes of scheduling. Mr. Cadet, can you tell me from your side where things are at and what you'd like to request from the court in terms of a schedule going forward to get this resolved?
Thanks, Your Honor. So we're on a couple of different tracks here. We have a separate custody case with an existing custody order, and that case is 2022-19140 DC. In that case, my client has filed a motion to change custody, and we have an evidentiary hearing scheduled before the front of the court referee on November 20th. Once that's resolved, I imagine that we would be able to incorporate those new terms into a final judgment of divorce in this case. As to property and debt, there is no real estate. There are a few items of personal property that need to be divided, as well as some debts, particularly one debt on a Harley motorcycle that is in both parties' name needs to be divided. And we're looking to get some more information on that presently. Now, we did file counterclaims for divorce against Mr. Ingersoll, who is residing at this time, as far as we know, in the Roscommon County Jail. And we also entered today a default against Mr. Ingersoll for failing to answer the counterclaims. Therefore, what we anticipate happening is once the issue of custody is resolved after the November 20th referee hearing, we will plan to submit and file a motion to enter a default judgment of divorce covering all issues.
Okay. Then I think what I'm going to do, just as a control date, the court will just simply set this for a status conference in about 60 days with the idea that prior to that, you would be filing that motion for entry of a default judgment. But I would just be setting that more as a control date. So in case that doesn't get filed, we have another date on the calendar to come back. Do you have any objection to that?
No, thank you.
Okay. Okay. Anything else I can address for your side today, Mr. Cadet?
No, thank you. Have a nice day.
Okay, thank you. That's all for today, and all parties on this case are free to disconnect. Okay, Mr. Leonardson, are you able to hear me okay?
Yes, I am.
Thank you. And Mr. Dundon?
Yes, I can, Your Honor.
Okay. We're on the record in Tabaka versus Tabaka. This is case number 2219040. If I could just have both counsel put your appearances on.
Yes. Good morning, Your Honor. Mark Dundon appearing on behalf of Lisa Tabaka. She should be, Your Honor. I'm gonna have to call my office. She's supposed to be on Zoom right now. She said she was in the waiting room from my office.
Okay.
If you have
I have a N Borovich or Borowitz. Would that be it?
that should be it, Your Honor. Thank you. That's got to be her. That's the office manager.
Okay. I didn't recognize that name as
Yes,
a
sir.
litigant, so I'll bring them in right now.
Thank you.
And Your Honor, Dave Leonardson representing Kenneth Tabaka.
Okay. All right. We're on the record here today. This is set for a status conference as well as motion hearing regarding a mediation agreement. And that motion was on behalf of your client, Mr. Dundon. So, Mr. Dundon, can you kind of tell me where things are at, and to the extent you have argument on that motion, you can go forward with that as well.
Will do, Your Honor. We settled this Friday afternoon. Mr. Leonardson and his client came over. The four of us sat down. So we were hoping to put a pro-con on the record, Your Honor, if possible today. And I could add the terms that we agreed to during that time, if the court's all right with that. And I've got a judgment basically all the way drafted, Your Honor. I just have to, Mr. Leonardson and I have to dot the i's, but other than that, it's basically done, so we could get it to the court very quickly.
Okay, Mr. Leonardson, any objection to taking proofs today?
No, that's expected, Your Honor.
Okay, Ms. Tabaka, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
I do.
Thank you. You can lower your hand, and Mr. Dundon, please proceed when you're ready.
Thank you, Your Honor. Could you please state your name for the record?
Lisa Nicole Tabaka.
Okay, and you were married to Mr. Tabaka on August 21st, 2010 in Johannesburg, Michigan. Is that correct?
Yes.
Okay, and you have two children, Carly Grace Tabaka and Lucas Adam Tabaka, correct?
Yes.
And are you currently pregnant?
No.
Okay, you came to my office to file a complaint for divorce, correct?
Yes.
And at the time we filed, had you been living in the county of Otsego for 10 days?
Yes.
Had you been living in the state of Michigan for 180 days?
Yes.
And would you say there's been a breakdown of the marital relationship to the extent that the objects of matrimony have been destroyed and that there remains no reasonable likelihood that the marriage can be preserved?
Yes.
Okay, and you met up with the four of us to finalize an agreement, correct?
Correct.
Okay, and you understand that as far as spousal support goes, this is going to supersede the mediation agreement, correct?
Correct.
And you understand that Mr. Tabaka will owe you $1,150 for all past spousal support, correct?
Yes.
And that he will then pay you $400 a month starting December 1st, correct?
Yes.
And that will go until the March 1st of 2025, correct?
Yes.
The payments will be on the first of the month?
Yes.
Okay. And you also had agreed to an extra Thursday of extra Thursday overnight of parenting time, correct?
Yes.
Okay, but as of right now, you're willing to agree to that extra Thursday that it ends when the kids start school on Friday, correct?
Correct.
Okay, and then Mr. Tabaka will then have every other Tuesday from 6 to 8 p.m., correct?
Correct.
Okay, and you're going to be responsible for your own car payment, correct?
Correct.
Okay, and okay, sorry, Your Honor, I'm just looking at my notes here. And you understand that that spousal support agreement we came up with is binding and cannot be revisited, correct?
Correct.
Okay, and do you find this judgment that we have proposed, do you find it to be a fair and equitable division of the marital property?
Yes.
And do you find it to be in the best interests of your children?
Yes.
Okay, and the friend of the court has already made a recommendation as to child support, correct?
Correct.
Okay, and you wish that to continue?
Correct.
Okay, no further questions, Your Honor.
Mr. Leonardson, did you want to take any testimony from Ms. Tabaka?
Yes, I do, Your Honor.
Okay.
As the recommendation from the friend of the court was that Mr. Tabaka was to pay $476 per month for child support. Is that correct?
Yes.
And that was in addition to the agreed to amount now of $400 per month to you for spousal support.
Correct.
That spousal support is supposed to end in March of 2025, I believe, right?
Correct.
As to parenting time, my client originally thought he had an agreement with you that the times for weekend and Friday parenting time was to end at 6 p.m. And he was requesting that the Thursday night would be from 6 p.m. Thursday night to 6 p.m. Friday night, with him delivering the children to you at 6 p.m. Friday night. Are you disagreeing with that?
I am disagreeing. I am disagreeing with that. It was written up in the judgment that Mr. Dundon wrote up that it was from 6 p.m. Thursday to the start of school on Friday.
And in addition, there's a agreement by the parties that my client was to pay a lump sum amount of $750 within the next 90 days that would be agreed to amount of paying for any arrearages as far as spousal support or other debt he owes to you. Is that correct?
Yes.
Sorry, Your Honor, that's not correct, but I'll wait to.
Yeah, I thought it was 1150.
It is, Your Honor, including the stuff, the payments were going to start November 1st, the $400 a month ones, but instead of starting November 1st, we just added it in. So it's the $750. So Dave's not wrong that that's the that was a number. It's just we were starting $400 a month on November 1st and we added it in.
Yeah, so that's just the difference between starting in November or starting in December, but the amounts come out to the same amount.
That's correct. That's what I have written in the judgment, Your Honor.
Okay.
And is it true that it ends March of 2025?
Yes.
I have no further questions of this witness.
Okay. So, I mean, I think we have the statutory grounds. It sounds like there might be still maybe a wrinkle there with regard to the parenting time on Thursday and the exchange time on Friday. council, how do you want to handle that? I mean, I can make a finding that the statutory proof's been met. If you guys want to work that out for the terms of the final judgment, Mr. Dundon.
Your Honor, if I may, my client's already compromised, and we would posit that as of right now, there was an evidentiary hearing that was conducted, and there is a final order with Mr. Tabaka actually getting less time, but she's agreeing to extend it. So I would, if they want to file a motion to get more time, I think they have to do that at the front of the court, Your Honor. That's what we're willing to do. And like I said, she's giving an extra 2 Thursdays a month. So.
All right, Mr. Leonardson.
I would put my my client on a stand just shortly, but it's my belief that he is still asking for till 6 p.m. on Friday. And it would be not necessary for us to file a motion, and we would do that. We do want the judgment of divorce signed as quickly as possible and acted upon, and we would file such a motion.
Okay. All right. So then the parties should present a judgment reflecting the current agreement, to the extent that Mr. Leonardson, that your client wants to have that parenting time go until the end of the day on Friday. Then I would agree with Mr. Dundon. There would need to be a motion filed to modify that within the front of the court. But otherwise, I think we have the statutory grounds for divorce. But Mr. Leonardson, was there further testimony you wanted to take from your client today?
Well, I would like him to clarify his position as far as the time on Friday.
Sure. Okay, Mr. Tabaka, can you unmute, please?
Okay, hello.
Yes, thank you. Could you raise your right hand, please, sir?
Yep.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can lower your hand. Mr. Leonardson, please proceed.
Mr. Tabaka, you've heard the testimony so far. Was it your understanding that you had the children for overnight from 6 p.m. Thursday to 6 p.m. on Friday, and that was the agreement of the parties originally?
Yes, it was my understanding. That's what we had agreed to when we had our meeting. There was a lot of back and forth where I was leaving the room and you and Mr. Dundon were talking. And so when I came back to make an agreement, excuse me, you had told me that that she had agreed to the 6 p.m. Friday, and then also that it was the $750, not the $1,150 number to cover the arrearages.
Do you understand the court's position that we would file a motion? We'd go ahead and close on the judgment, get that filed, and then we would have the opportunity to file with the court a motion as to the Friday time.
Yeah, correct. I can do that.
Okay. I have no further questions. Or do you have any further questions? I should ask. Do you have any questions about the judgment?
Yeah. So this would be, I would still be signing off on the judgment, and then later on we would go back with friend of the court, or how is that working?
Yeah, but do you understand what the judgment entails?
Yeah. Yes, I do.
I have no further questions.
Thank you. Mr. Dundon, did you have any questions for Mr. Tabaka?
Just briefly, Mr. Tabaka, I printed out a copy of the judgment for you and Mr. Leonardson, correct?
Correct. I have it right here.
Okay. And I would direct your attention to excuse me, page the spousal support section, which sorry, I just had it up. That would be on page 9, under the spousal support paragraph. And you see where it says a one-time payment of 1,150, which will average or do with it 90 days of the execution of this judgment.
I do see that.
Okay. And that's
However, but that's not
good.
what I had agreed to. I had
Okay.
agreed to the 750.
Well, Your Honor, I guess I'm not sure what we can. I mean, maybe we could. Sorry, I'm kind of at a loss, Your Honor. That is what I wrote in there. I'm not saying that Mr. Tabaka's, lying. I mean, if he had a different understanding, but that is what I had written in there.
Here's how I want to go forward. Number one, we've got the proofs preserved. So the court finds that their statutory grounds have been met for divorce. I think from what I'm hearing that these are a couple, I think fairly minor issues that I'd like to give the parties a chance to see if those could be hammered out before we start scheduling evidentiary hearings and so forth. So my suggestion would be simply to set this for a control date status conference in 30 days. If the parties are able to hammer those last two little issues out, then the court will sign that judgment when it's presented. We don't have to have that hearing. If not, then again, the court will make a decision on those things here if we need to. So that'd be my suggestion. Do you have any objection to that, Mr. Dunman?
No, absolutely. That makes perfect sense, Your Honor. And I guess the only thing for the court to address would be the potential $400 difference, because I believe we have clarified that any custody issues have to go through the front of the court road, correct, Your Honor?
Right. Yeah, you're right. I mean, I think really what we're down to is it 1150 with no payment in November, or is it 750 and some other payment schedule? Sounds like so. It may just be, I think, a matter of clarification and communication between the parties.
Yes, Your Honor.
Okay, Mr. Leonardson, do you have any objection to that? You were muted, I'm sorry.
No, Your Honor.
Okay. Okay, thank you. That's all for this hearing today, and all parties are free to disconnect at this time.
Thank you, Your Honor. I'll call you, Dave. Thank you, Judge.
Good morning, Your Honor.
All right, good morning. Mr. Tubbs, are you there? Can you hear me?
Yes, I can hear you. Good morning.
Okay, we're on the record in Wood versus Tubbs, case number 2219078. It looks like we have all the parties present, and Ms. Doak is here on behalf of Ms. Wood. The court set this a while ago as a review hearing, and actually I had said it before the referee, but we have it here today. So, and it's a review for some parenting time that resulted from the hearing that we had this summer. So Ms. Doak, from your side of things, can you tell me just kind of the status of where we're at and how things are going from your
Sure. So the court entered an order for supervised parenting time, asked me to draft a letter explaining if the parties could reach a resolution with regards to who should be the supervisor. We were not able to reach a resolution, so rather than write an ex parte letter to the court, I wrote kind of a joint letter, had the other party sign it and submitted it to the court. And then thereafter, the court set a review hearing. The parties still have not been able to agree on who a supervisor would be. The child, Jaden, is currently 15 months old. Despite my client being willing to allow the dad to come to her house to have parenting time in the interim, he has not, since the entry of the last order or since last court hearing, come to the house for any kind of parenting time. So it's been a long time since the child has seen him. He's also not called and asked or tried to have any contact with the child. He works at the family fair that's less than a mile from where the child is. My client has offered her mother, Danette Johnson, as a supervisor. The rationale for that being that the child knows Danette and knows my client, obviously, but also the child is 15 months old. And for the child to be comfortable in a new setting, it would be important to have a supervisor that the child is familiar with, and also a supervisor that knows the child's needs. He suggested his mother as a supervisor. Again, she doesn't really know the child at all or haven't had any time with the child. So Jaden is not familiar with her. There are concerns about the defendant's behavior. When he came over in the past, he's referred to my client as a bitch in front of the child and other people. And his mother was present for that and didn't say anything about it. So we're asking that the court, if the court is going to enter a supervisor, that be Danette Johnson, my client's mother.
All right, Mr. Tubbs, anything that you'd like to state from your side of this?
Yes. I actually wanted the supervisor to be either my aunt, Alyssa, she owns a daycare. So I felt that would be a really good setting for Jaden, or my grandma Dar as well, which they have both met Jaden. They just haven't really been around them too much because they try contacting Tafia, but she doesn't really answer them, or whenever they ask to come over, she always says that like she has an excuse for why they can't come over. Either, they're going to run into town, or he's napping at the moment, or she's got to go to work or something like that. So my family members really haven't been able to see him much at all, which, referring to my mother as a supervisor, I know that Tafia does not want her to be that. She made that very clear. So that's why I decided to go with my aunt and my grandma. And also I've tried contacting Tafia and she just hasn't answered, which I'm not making an excuse for why I haven't continued to try contacting her, but the times that I have previously, in the most recent time, she hasn't answered me when I've tried to make attempts to go see Jaden.
All right, so just looking at the file, Ms. Doak, the court did receive the letter that was signed by yourself, Mr. Tubbs, that outlined each of your requests for a supervisor. And in response to that letter, the court did issue an order on June 23rd that set Ms. Johnson as the supervisor and outlined what her role was to be. So following that, the court did issue an order establishing who the supervisor was and very clearly set forth the parenting time.
I did not get that order.
Yeah, I mean, it's here in the file.
I did not get a copy of that order.
Neither did I.
I haven't received anything.
My office sent it out on June 22nd of 2023. So We'll mail another copy out to the parties, but that's the current order that's in place, so I think what we need to do is have some parenting time pursuant to that order, and like I said, it very clearly provides who's gonna supervise and what their role is, so.
Okay.
We're gonna go forward based on that order. The court will set this for another review hearing in about 90 days. And so let's see, once we actually start going forward pursuant to that order, let's see how things are going.
Thank you, Your Honor.
Okay.
I will get a copy of that. I appreciate it.
Okay, that's all for today. All parties are free to disconnect this time.
Thanks.
Thank you, Your Honor.
Hello?
Yes, Mr. Are you Tyler Renkevich?
Yeah, finally it started working.
Okay, and let's see. It's like Miss Renkevich is connecting as well, so just one second. All right, Mr. Renkevich, if you can unmute, please. There we go, Miss Renkevich now. Okay, good. Can you hear me?
Yep, all set. Sorry about that. I figured I'd just leave and come back.
That's okay. All right, we're on the record in Renkevich versus Renkevich. This is case number 2319259. We have both parties present here. I have this set as a final hearing for entry of a judgment of divorce today. Mr. Renkevich, is that how you wanted to go forward?
Correct.
And
Yes.
Ms. Red, is that how you wanted to go forward as well?
I did want to, I haven't received any paperwork at all to see the separation of property. So I'm still waiting to see that.
Okay, I'm looking at a proposed judgment of divorce here. It looks like that you signed that back on the 21st of October.
Mm-hmm.
Do you recall signing that?
Yes, and we hadn't had that part filled out yet.
Okay.
So what has been filled out since then, I don't fully agree with. So I wanted to be able to get that paperwork, and I guess I don't know how to go about rejecting the proposal besides writing up my rejection and sending that back in.
Okay, so what parts do you not agree with?
I believe that it states that I would give up the ownership of the home in exchange for Tyler giving up ownership of the vehicle that we share.
Okay, I don't see that as part of this. Mr. Renkevich, can you speak to that?
That was the plan. We've originally had that plan since the last hearing. Also, the Zoom meeting, we've talked about this for months and months, and that's always been the agreement. So this whole new idea that she has is because she lost her job, and then this all just changed suddenly.
Okay, Ms. Renkevich, aside from that, are there any other issues?
No, not really.
All right, so are you saying that you won't agree to that, or you just want to see what Mr. Renkevich has written up with regard to how things are going to get divided?
I wanted to see that, but I don't agree with it either way. No.
Okay. All right, so we're not going to be able to finalize the divorce today then, unless we have an agreement as to issues regarding property. So the next step to try and reach an agreement would be to refer this to mediation. So the court's going to do that. That's a process where you meet with a neutral third party. Neither of you is required to reach any agreements during that process, but that person will help try to facilitate it and see if you can. If you're able to reach an agreement, then we can go forward with the divorce pretty quickly after that. If you're not, then we'll have to set it for further hearings before the court. Mr. Renkevich, did you have any questions about that?
Just this was a whole waste of time that she changed her mind. We already agreed upon things, and it is what it is, I guess.
All right, Mr. Renkevich, do you have any questions?
Nope.
Nope.
Okay. All right, so the community mediation folks will be reaching out to both of you. When they make that contact, it's important that you both follow up with that so that we can get a date and time set that works for both of you and hopefully get things resolved. Other than that, you're both free to disconnect at this time.
Thank you.
Okay, we have council connected on the next hearing, Stevens versus Stevens, case number 1917843. If I could have full council put your appearances on.
Good morning, Your Honor. David Delaney appearing on behalf of plaintiff Matthew Stevens, who was present in my office.
You're muted, Mr. Blumberg.
Now I can do that. Okay. I think you were preventing me from.
I must have switched the settings.
Or you just tired of hearing from me already today.
Those are good settings, Judge. Just kidding. Mrs. Delaney has that at the house too, so I'm equal footing here.
Okay, we're on the record here in a continuing series of hearings with regard to implementing the judgment of divorce here. So I believe, and I'm sure the parties will correct me if I'm wrong, we had a hearing back in October. Mr. Delaney, on behalf of your client, can you tell me where things are at this point?
Yes, following the October 2nd hearing, my client promptly listed the property for sale, and Mr. Blumberg signed that listing. There was some question about getting it on the market because of the documents that came through, but it's been on the market for a month now. That's number one. Number two, we have an offer to purchase with pre-approved financing, but Mr. Blumberg didn't sign that. My client did. Number three, my client is still pursuing refinancing. And so I think Amrock contacted Mr. Blumberg and requested documents, but I don't know the status of that. So the bottom line is, Judge, it's listed for sale. I think that's the primary issue for the court. And I hope that we can get that pending offer signed by Mr. Blumberg.
Are you saying that there's currently an offer out there?
There was at the last hearing. It lapsed. And so that individual, it's a family member, has pre-approved financing sufficient to pay Mr. Blumberg's client. But Mr. Blumberg had a question about the financing, but that's not really relevant. He's pre-approved, and so it didn't get signed, and so it would need to be reignited. And we may have closed by now, so I'm just waiting to hear from counsel on that.
All right, Mr. Blumberg.
If this were really the facts, we wouldn't be here today. It is just astounding to me that counsel will come before this court and make these representations. This is either the third or fourth appearance we've had post-judgment to effectuate the terms of the judgment. The fact of the matter is, first of all, we were supposed to agree on a person to list the property. I am suing Miss Parks, who has the current listing, her husband. So I didn't want her, but Mr. Delaney went ahead and listed the property with her anyways. Okay, we're past that. This family member has never been approved for financing. In fact, there were issues related to, because this is a HUD sectional, the foundation became an issue. There is no accepted offer. There is no financing lined up. In the meantime, Mr. Stevens went back, who he already told us he was turned down the first time for refinancing, is now gone to Rocket Mortgage. There are all sorts of contingencies, one of which is he has to have an approved profit and loss statement, which he doesn't have. He hasn't filed his tax returns. He's already acknowledged that. So this is just a bunch of, it's pure sophistry. It's just smoke and mirrors, so this gentleman doesn't have to pay what the court has ordered him to pay. We are no closer to being paid than we were 6 months to a year ago. I'm flabbergasted. And every time we come before the court, my client has to pay more attorney's fees. So, Judge, I just hope you can see through all this. It's a delay. It's been, what, a year now since we've had the trial? I'm just flabbergasted.
Judge, let me respond and simplify. Number one, Mr. Blumberg.
Hold on.
Okay, I'll wait, Judge.
Okay. I need to ask one more question. So, Mr. Blumberg, if the property's listed right now, and whatever happened with the proposed buyer or whatever, let's just set that aside for a second. If the property's listed, what is your suggestion, or what would you be asking the court to do from now going forward in terms of implementing this?
My sense is that the listing agent has no great motivation to do anything with this property. This family member just sort of reappeared out of nowhere. And again, he wasn't approved. There was a pre-approval, and again, that fell through. That didn't happen. First of all, if you're asking me what I would prefer, is that the property be listed by a reputable agent and put on the market. But again, on the other hand, they're saying, he's been approved through Rocket Mortgage for refinancing. That's not the truth. I've got the document in front of me about it is conditioned upon, 8 different things. So he's no closer to getting his money than he was at the time of the divorce. I want to be responsive to the court's question. I would ask the court to order that this property be listed by someone who is a reputable real estate agent in the area. I provided Mr. Delaney with a list of 3 different real estate brokers. He didn't choose any of them. He just went along with Mrs. Parks, this woman from Lewiston. I don't know. I mean, I'm just at my wit's end. It just isn't right. And Your Honor, you have been incredibly tolerant in listening to these stories each and every month that we come back. I'm asking the court today to award us at least our attorney's fees for having to yet come back to court for a 3rd or 4th time. I don't know. I'm at a loss for words. It's incredibly disappointing to me that no real effort is being made to pay my client the money that the court has ordered him to pay.
All right, thank you, Mr. Delaney.
Well, one question and a tsunami answer. First of all, the property had a lien on it that got discharged. Secondly, Mr. Blumberg sent me a defective power of attorney that his office produced that was not notarized, which is contrary to statute. Suddenly it got notarized, even though his client's in prison. We'll leave it there. That's resolved. That took up most of the summer to get those 2 issues resolved. We came to court. It's now listed for sale. It doesn't matter who listed it. It goes into the MLS. So every real estate broker in the state, if not the country, can find that property online and buy it. Doesn't matter who listed it. So we've complied with that. Number 2, sign the purchase agreement. She'll be paid. Number 3, I didn't represent that my client had been approved for financing, but back to that pending offer, I sent to Mr. Blumberg in an email a letter from the bank saying he was pre-approved. But in any event, Judge, that property has an MLS statewide, countrywide, and anyone can make an offer on it. Thank you.
Okay. All right, thank you. So without some type of evidentiary hearing, obviously the court can't necessarily make any findings with regard to representations of either side. I do think, though, the court obviously has an interest in enforcing its orders, and this has been delayed, I think, unnecessarily. We do have a realtor. It is listed. I think there's a big difference between a property being available and could, possibly be seen and viewed by other parties on websites or realtor.com or the MLS system. There's a big difference between that and a real estate agent who's actively marketing the property and trying to get it sold. So, and I'm not satisfied that the agent that's been chosen is doing that. And in light of how long it's taken, I think at this point, the court needs to intervene in terms of which agent is used. So within 7 days, the court is going to ask both sides to submit 3 realtors to the court, their choices, and then the court will choose from that list a realtor to list the property within 7 days of the court notifying the parties, and the parties need to sign or do anything that needs to be done to cooperate with the realtor that the court is going to order to list the property. And then the court will set this for another hearing in about 60 days. That'll give time for the court to make its choice as to the realtor who will market the party or the property, and for the listing to get switched and some time to see if we can get this thing taken care of. And we'll go from there. Mr. Delaney, anything further from your side?
Do you want a filing with the court, or can we email the court staff and accomplish that? What's your preference?
I'd like to have it in writing, so just, 1 page submitted to the court, because I'd like that to be part of the file.
Very good.
Mr. Blumberg?
Judge, let me just indicate this. If Mr. Delaney's representations are true and there is a prospective buyer out there that has been approved, I'm all for it. I've already signed whatever I've been provided. But between now and 7 days from now, if that offer is still alive, let's get this thing closed.
And if he can sign it, he didn't sign that offer.
I signed it under a power of attorney. I did sign it, but I'll sign it again.
Send me the signature you put on that in October.
Just let's get it done.
No, I'm just saying, just send it over.
Okay.
If you signed it.
I'll let you guys negotiate over that off the record, but that's how we'll go forward from here. I'll look for those submissions from the parties, and both sides are free to disconnect. Mr. Blumberg, if you want to stay on, we have one last status conference, and I see opposing counsels present in the Zoom waiting room.
Thank you, Your Honor.
Okay, Mr. Garfield, are you able to hear me okay?
Yes, Your Honor.
Okay, we're on the record in Glazier versus Glazier, case number 2319311. If I could just have both counsel put your appearances on.
Good morning, Your Honor. Elliot Blumberg on behalf of Beth Glazier, the plaintiff, who is appearing via Zoom from my office.
And Jeff Garfield on behalf of Travis Glazier.
All right, we're set for a status conference in this matter today on behalf of plaintiff. Mr. Blumberg, can you tell me where things are at?
Yes, Judge, we had had a default entered against Mr. Glazier in this matter. Mr. Garfield filed an appearance lately, and we've agreed to set the default aside, conditioned upon getting this matter resolved once and for all. It's been pending for quite a while now. Mr. Glazier is back in jail for, we understand, a minimum of 90 days. We'd like to go forward and move this case along as quickly as we can.
Okay, Mr. Garfield?
Yes, Your Honor. Same as Mr. Bloomberg, we'd like to move this along. I believe there was something about Mr. Glazier getting out November 12th or something like that after he posted bond. Well, they posted bond, but they said they got to hold him. And then I'm sure he'd be going before you again. But we can move this along while he's in jail, and I can go see him there.
All right, Mr. Blumberg, are there assets or debts that are going to need to be divided, or what kind of issues do we have?
Well, we have the marital home that my client has been living in and paying all the bills. Mr. Glazier, has moved on in terms of another relationship. There are some bills, debts that need to be paid. In the meantime, she's recovering from a vicious dog attack, the result of which she almost lost an arm. But she's not being able to work right now. And so we're certainly in need of some help from Mr. Glazier to contribute to the family obligations. But there's some limited assets, the marital home being the biggest, the most significant of which, and some debt. I mean, I think we could probably get this matter resolved pretty quickly if Mr. Glazier wasn't incarcerated, but or have a 2-hour evidentiary hearing for the court to decide how to divide things up.
All right. Do you have any objection to mediation?
I'm not real good. Well, if we do it through Zoom where the parties aren't in the same room, I think that would probably be more appropriate.
Okay. Mr. Garfield, any objection to mediation?
No, I have no objection to that. I think we need to do some discovery and document exchanging to see what we got going there. But once we do that, then we'll be able to go into mediation with our ducks in a row a little bit.
All right, so I'll just order that discovery to remain open and mediation to occur within the next 60 days. And then I'll set it for a status conference at that point. Any objections to that, Mr. Blumberg?
No, Judge, that's fine.
None
Mr.
here.
Garfield?
No.
Okay. And I believe that community mediation is still conducting those all by Zoom.
They are.
So that should not be a problem. Okay, I'll put that into an order. That's all for today. Both sides are free to disconnect at this time.
Thank you, Judge Mertz.
That concludes the court's morning docket. The court will be